Hi, everyone. Did you know sometimes your silence can be used against you? This is Christina Williams with Just Criminal Law.
And this is David Mann, legal storytelling specialist. Okay, your silence can be held against you. I thought that was protected by Fifth Amendment rights, your right to remain silent.
Right. So typically, when someone is arrested, that is, the law enforcement officer has said, I'm arresting you for X, they will typically read that person. They're supposed to read that person their Miranda warning. That is telling them exactly that. They have the right to remain silent, among other things. And that only happens once you're not free to leave and you're under arrest. So your Fifth Amendment rights come into play then.
All right, so yeah, once they read your rights, then, and we've talked about this in other videos, then it's really up to you to actually remain silent so that you don't incriminate yourself and get into trouble. So that's the arrest, and then this also applies at trial, right?
Right. When you stand trial, the judge instructs the jury that they cannot hold your silence against you. That is, the fact that the accused does not take the stand cannot be used in determining his guilt. So the jury's not allowed to deliberate back in the jury room and say, well, he must be hiding something because he didn't take the stand. He must be guilty. And the judge absolutely says that's not okay. It's everyone's right to remain silent during the entire trial. Post-arrest, you have the right to remain silent, and that follows you all the way through your case.
That rule really makes sense because it otherwise could look, like you're hiding something, but that's all that's a subjective thing. Like, we seemed to be kind of hiding something, and there's no hard evidence there, which is, I'm sure, why that rule exists. But you led off this video by saying that sometimes it actually can be used against you, so explain that.
Sure. 10 years ago, the Supreme Court looked at a case called Salinas v. Texas. And in that particular case, an individual was accused of shooting two brothers that he had met the night before at a party. Now, law enforcement brought Mr. Salinas in to question him. He was not under arrest, and they were investigating the crime. Now, they questioned him for about an hour, and one of the questions that they asked him was, will the casings at the scene of the crime match those that would be ejected from your rifle? And he remained silent on this. In fact, in the report, the officers note that he clenched his fists, he looked down, he started to become nervous, or act nervous in their opinion, and did not answer that one particular question. Now, law enforcement followed up that question with other questions, and he continued to answer other questions. And then when it came time for his trial, the prosecutor pointed that out to the jury. He remained silent when he was asked that one question, and argued that he was hiding something, that he didn't want to answer that question because he was guilty. And, well, that created an appeal issue. And so it went up through the courts of Texas and finally landed at the Supreme Court of the United States.
And at that point, what was the ruling?
Well, even at that point, it was interesting because there's 9 Supreme Court justices, and 5 of them found that the prosecutor should have been allowed to comment on his silence, and the other 4 disagreed. And it came down to the point in time that they were. That is, he had not been read his Miranda rights. He'd not been told you have the right to remain silent. He was not under arrest at that point. In fact, they let him walk out of that interview. And so the Supreme Court said, prior to Miranda, when someone is being questioned, prior to the Fifth Amendment coming into play, a prosecutor is allowed to comment on what the person remains silent about.
So that means, and it ruled 5-4, so it ruled in favor of the idea that if you're silent, that can sort of go into the mix once you are arrested and once you are at trial. That can be referred to as being construed as hiding something. Is that right?
Right. That's what they call consciousness of guilt, and the prosecutor is allowed to comment on it. But again, remember, we are talking pre-arrest, so it's before you've been arrested and charged with a crime that they're allowed to talk about what you were silent about and what you were not silent about.
But there is one way that you can help yourself out of this whole situation pre-arrest when they start asking you questions, and what is that?
Well, that is to never talk to the police. And I, have a video specific to that exact explanation, but never talk to the police without a lawyer.
And you should also add in probably, I am invoking my Fifth Amendment right to remain silent. Is that right?
Right. If you are being questioned by the police, absolutely say, I'd like to plead the Fifth, or I'd like to remain silent, and I want my lawyer here.
Okay, great. So, and that lawyer should probably be you. So how do they do that?
Sure, we'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.